Well, good morning, Attorney Polito. Today's date is March 23rd, 2021. We are scheduled for one oral argument this morning, and that is yours. And that will be in the case of Sheffield Lake versus John Houlihan. It's case number 20CA011666. I'm Judge Teodosio. I'll be presiding. Joining me on the panel this morning for today's oral argument are Judge Lynn Callahan and Judge Betty Sutton. So good morning, judges. Appellee Sheffield Lake has waived their oral argument, so we will only be hearing from Attorney Polito on behalf of the appellant, Mr. Houlihan. Attorney Polito, you will have 15 minutes to present your argument. And Judge Callahan, if you'd be kind enough to keep track of time for us and let Attorney Polito know when he's getting close to that 15 minutes. Okay. The argument is being visually and audibly recorded, and we are live streaming on the court's YouTube channel as we speak. A link to the video does appear on the court's website. I don't think it's applicable here, but it's always good for us to announce the court's policy. We always caution attorneys not to use the names of victims or minors during oral arguments. The judges in this case, Attorney Polito, have read the briefs, and we are prepared to proceed when you are. So whenever you're ready, counsel.
Thank you, Your Honors. May it please the court. I don't believe my argument will take the 15 minutes. As the court is aware from reviewing these briefs, this is a matter of an improper backing. We believe, certainly after the litigation occurred, that the judgment of the court should be reversed because the evidence was insufficient to prove the state's case, and any evidence that was obtained certainly consisted of information that was contradicted by the witnesses, and the judgment is against the manifest weight of the evidence in this case. So what we have in this case is a procedure where Mr. Houlihan, when he gets home every evening, he would back into his driveway. The maneuver is basically coming to the east side of the road, assuring that there's no vehicles coming. He then moves his car onto the west lane, turning into the west lane, and then backing straight into his driveway. He did that this particular evening. There wasn't a vehicle behind him. The evidence presented at trial, which was contradictory from Ms. Wilson, who was the driver of the other car, would have you believe that she was following down Ferndale for a number of blocks, over a mile, following Mr. Houlihan's car. In fact, that was drastically contradicted by her passenger, Mr. Terrell, who indicated that no, they weren't coming down Ferndale, but for less than one block. They were actually coming from Ms. Wilson's home. Why is that important? It's important because Mr. Houlihan testified consistently on these procedures that he makes. Ms. Wilson would have you try to believe that Mr. Houlihan was acting erratically by flashing his lights and doing maneuvers that were unusual. So rather, what she did was turn down Ferndale from the block that is her house, West Road, which is less than 0.2 of a mile from the point of impact. She had three passengers in the car, which is excessive, and likely was distracted. The testimony doesn't add up. Both she and the passenger would suggest that at some point in time they did see Mr. Houlihan sitting on the eastbound lane of the street. They waited for 1 full minute, stopped. But yet when Mr. Houlihan was in the process of doing his maneuvering, Ms. Wilson says that she didn't see the vehicle even when it struck right in front of her behind the driver wheel. And further, being stopped 10 feet behind Mr. Houlihan, she would have you believe that the scratch along the entire side of the vehicle occurred not because she was speeding, didn't see the car, but because Mr. Houlihan was backing up, which is, again, against the sufficiency of the evidence or manifest weight of the evidence in this case. As the court is aware, with regard to improper backing, the standard applied by the courts have been that it's a general duty where Mr. Houlihan would have to show that, in fact, he exercised reasonable care before instituting his maneuver. Mr. Houlihan's testimony fully describes the care that he typically uses, as well as was used in this evening. He was well into making his maneuver and ultimately backing up into his driveway. There was no car behind him when he started this process. And the point of impact was, we believe, as a result of Ms. Wilson being distracted or not exercising her standard of care and actually colliding with Mr. Houlihan's car. And we believe that the facts presented at trial do not support the conviction in this case, and we respectfully ask the court to overrule the judgment in this case. If there's,
excuse me, it sounds like you're making a credibility argument on a manifest weight basis. Can you be more specific as to what elements you don't think were proven by the state on the sufficiency argument?
Yeah, and the sufficiency of the evidence, certainly there has to be credible evidence that the elements with regard to Mr. Houlihan's backing were such that he had a substantial lapse of due care. Nothing was provided, not only with regard to the contradiction in the evidence going to the manifest weight, but even to the sufficiency. There was nothing presented that even the witnesses there couldn't tell you whether Mr. Houlihan was driving forward or was actually in the process of backing up. The evidence is really unclear as to what transpired. That's where the sufficiency of evidence comes in.
Thank you. Judge Sutton, do you have any questions?
I do not. Thank you.
Yeah. Judge Callahan?
I guess I have one since there's time. I noticed that in reading your brief, you broke down your client's maneuver, so to speak, you know, east lane, forward, backward. But counsel, isn't the entire process him backing into his driveway? I mean, I guess I would argue, aren't you kind of, I don't have a better word here, splitting hairs when you say, okay, well, but here he was driving forward and here he was driving backwards. Wasn't the whole thing about him backing into his driveway?
Your Honor, I would have to agree that the maneuver, which began with him crossing to the eastbound, driving his car forward onto the west lane to position so he can back up, is all one act. The backing up itself, obviously, is when he puts the car in reverse and actually backs into his driveway. There's nothing behind him in his driveway. But that is a maneuver that begins with him leaving the west side, westbound lane, going into the eastbound lane, and then curving onto the westbound lane to make his maneuver back.
And frankly, I can look this up, but would you remind me again where the damage was on her vehicle?
Yes, the damage began at the rear tire, right behind the rear tire of the driving side, her side. And there was a scratch that began there and ended at the rear panel, right before the rear tire of the car. And the depiction, I think everybody is in agreement with it, is that the car actually veered off the roadway so that at the point of impact, it wasn't going straight down the west lane, but rather was curving, I believe that would be north, was curving north, and that maneuver would be to avoid the impact. If she was stopped 10 feet from Mr. Houlihan, she could not have been going at a speed that she would not have noticed a maneuver being done so that she could stop her vehicle. Obviously, from 10 feet away, she would have seen everything that was going on. She would not have lost perspective based on her testimony that she was watching Mr. Houlihan stopped in front of his driveway. If she started to proceed, certainly she would have kept an eye on the vehicle to make sure nothing was happening. That's part of the incredulity with regard to this matter. She was obviously going much quicker. When she finally recognized that there was a car in front of her, she attempted to avoid the car, headed north, and that's when the contact was made between Mr. Houlihan's right front by the headlight corner of the car. And then as she passed by, it scraped all the way back to the rear tire up until the point she was able to stop.
So your argument basically is, if I understand, it's her violation of the assured clear distance law as opposed to your client's improper backing.
Yes, ma'am.
Okay, thank you.
Judge Teodosio, I do have one question, actually.
Sure, go ahead, Judge Sutton.
Counsel, thank you. Counsel, it was agreed by both parties, right? Testified to that, and you said it here today, that he traveled into the lane of oncoming traffic to make this maneuver, correct?
Yes.
Okay, and Mr. Houlihan admitted that he first checks his rearview mirror for other vehicles, but after he does that, during the maneuver, he no longer looks behind him, right, for oncoming traffic as he turns right and back into the driveway?
That's correct, ma'am. And I believe, although it's not in testimony, but I believe that once you do that maneuver and you start going to the right, you can see oncoming traffic out of the passenger side windows and back windows. So looking, it's not as if he stops there for 1 minute. He doesn't. He goes into the eastbound lane, stops the momentum, double checks, and then makes his turn. While he does that, he can see from the passenger side if there's any incoming vehicles. In this case, West Road, which is where this young lady was traveling before she turned onto Ferndale, is very close to the point of impact. And at this point, when he did the maneuver, he didn't see a car coming.
Thank you.
Any other questions? All right, thank you for your presentation today, Attorney Polito. The court certainly appreciates your appearance by video. We will take the matter under advisement and issue a written decision, which will be mailed to you and Attorney Graves, representing the city of Sheffield Lake. And the decision will also be posted on the Supreme Court of Ohio's website. The court will be adjourned